Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
No delaying for what you saying, yo. Silly with my 9 million with the dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, I be while in the studio. You don't wanna vibe, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, nigga shorty, she a little cutie, yo. The way you shake it, make me wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. Fuck me, see, that's what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see, that's what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. Fuck me, see, that's what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see, that's what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see, that's what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you really my heart to me. Fuck me, see, that's what you got for me. Put more than dance with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Hello, hello, hello. Welcome back, guys. OCOV is in the building. What's up, what's up, what's up? Hi, everybody. How's everyone? How's everyone? And we have our lady, Miss Empowered Esquire TV with us today, guys. Yes! Yes! Miss Esquire, say hello to your people.
Hello, hello, hello to Diva Divine Light, and thank you for inviting me on. It's always a pleasure. And hello to OCOV.
What's up, Mama? For those who don't know Miss Esquire, can you introduce yourself to the people that are new to my channel?
Absolutely. So my name is Felicia Pearson. I am also here on YouTube as Empowered Esquire TV. I am a practicing attorney and educator. I'm here in the YouTube space, sharing my knowledge, breaking down these pop culture cases, and bringing some information to the misinformation and gossip.
Ow. And for my mods that know Miss Esquire's link, can you please do me a favor and drop her link, her YouTube link in the chat so that those can follow her? Later on, I will also leave her link in the description box. Okay, guys? So for those who would like to follow her, I will definitely leave you her link in the description portion of the video. So, hi, everybody. Well, we know that yesterday the government, well, actually, shall I say this morning, Judge Donnelly put in an order to push R. Kelly's sentencing. So she was being very nice. You see how I say Miss Donnelly is very fair. So I don't want to hear that she's not fair. She is very, very fair. She was nice enough to say, okay, I'm going to give you at least another 40 days because we know his sentencing originally date was May 4th of 2022. But now it is pushed to June 16, 2022. Thank you, Diva Time, for becoming a member again, baby. So now his new sentencing is going to be held on June 16th, 2022 in Brooklyn, New York. Cadman Plaza over there at the federal court building. So, Judge Donnelly was nice. Don't you think that was nice, Miss Esquire?
Yeah, I think that was fair. I wouldn't have granted it if I were her. But I understand that she wants to be as neutral as possible,
Right,
again, because she does not want to buffer their argument that she's biased.
right. That's absolutely right. And you know, we have been crazy out here in these streets because Miss Bonjean put in now I gotta find the paperwork again because ugh, really. All right, hold on. All right, is this it here? This is the 63 pages. She put in a 63-page motion for a new trial. Oh no, for an acquittal. I'm gonna share my screen. Uh okay. All right, is that my husband's phone ringing? Let me give me a second. I think that's his brother. Hold on.
Well, while we wait on Diva to return, I was telling Diva that it's been a challenge for me to even make time for my channel, much less for me to keep in the loop with all of the R. Kelly goings on. So while we wait, OCOV fam, can you just drop in the chat some current events in the R. Kelly goings on, kind of bring me up to speed a bit before Diva gets back? By the way, I see you, Karen A. And rocking with the truth. How are you? I haven't seen you in a minute. Also, hello to Atmos Love Zone. Hi to Spiritual Gangsta as well. I see there's a lot of crossover. I'm seeing a lot of familiar folks. Hello to Indigo Forever.
Hey guys, I'm back. Yes, yes, yes. Hello once again to my peoples. I love you was all. I'm glad you're all here. I'm glad Miss Esquire took her time out of her busy schedule to come and see us real quick. And we love you, Miss Esquire. Thank you so much for coming over. Guys, you see her name here under her avatar. It says $ Felicia P. If you guys can do me a great favor and hit your girl off for her time, please and thank you. I appreciate y'all for doing that. You know, I would love to bless her. So let's bless her tonight, okay? All right. I love you guys. It's her Cash App is $, P HYLICIA. Everything that is lowercase with a capital P at the end. If you guys can put her Cash App as well in the chat as you go along. And you guys know my Cash App is Diva Divine Light. It's here underneath my avatar as well. So, Miss Esquire, let's get you up to speed, as you said.
So I asked him to get me up to speed. Let me tell you what they put in the chat. He's guilty.
What they do? What they do?
I said, can y'all get me up to speed? And they put in the chat, he's guilty. I was like, well, duh.
We know that. We know that. She wanted to know what was going on with this acquittal. This acquittal. All right. Do you see this screen, Miss Esquire?
Yes, I do. I'm just dropping my my Cash App in the chat just to correct a grammar error that was in the link.
Thank you, my love.
Someone missed the I, so I'm just correcting it.
Thank you, my love. Thank you. Please do. Please do. All right, so guys, before we continue, does everybody hear us loud and clear? Are we good? We're not in the matrix. Give us a thumbs up that the sound check is good, please. I gotta open up my phone. My phone's about to die too. Darn it to heck. Okay. So now Ms. Bonjean put in the motion, the memorandum of law in support of a judgment of acquittal, right? Her table of contents consisted of her introduction, her argument, and her arguments were that the first one is the government failed to prove defendant guilty of the offense of racketeering count 1. And then under that, she puts the subs, and it's about the government's proof did not establish an enterprise, the common purpose, enterprise distinct from racketeering activities, person enterprise rule. The government failed to prove that the so-called enterprise's activities affected interstate commerce. Girl, that one was interesting. Then she also put in for the government's proof did not establish a pattern of racketeering. And then she divided that into Racketeering Act 1, Racketeering 2, Racketeering 5, Racketeering 6, and Racketeering 7, which is the bribery, sexual exploitation of children, Mann Act, and forced labor. And then Racketeering 8 as the transportation. And she broke it down with Geronda's case not Geronda, Azriel's case, which is Jane Doe number 5. Her pseudonym was Jane, so we all know her as Jane Doe number 5, but we know who she is. So her issue with Jane Doe number 5 is the transportation portion, intent, and violation of California Health Code. Remember, she got herpes by R. Kelly. That was her claim. He was convicted of that, so he did that. We can say that. It's not alleged anymore. Then Racketeering Act 8B for coercion and enticement of her. And then Racketeering Act 9, which is the Mann Act. Then they got transportation for her, coercion, enticement for her. They got that for her 2 times for transportation, Mann Act, forced labor, and another Mann Act. Oh no, that's Faith. And then they have Act number 12 for Faith for Mann Act and violation, as well as the intent, coercion, and enticement, and the New York Public Health Law. And then Racketeering Acts 13 and 14, which are for Faith, and it's forced labor and the Mann Act as well. Then the government failed to prove, part 2, that counts 2 through 9 of the indictment. That's all she says there, and then it's the conclusion. So she wants to throw the whole thing out. What do you think of that?
Well, that's her job. So if
Right.
she were to file this motion and not argue that the entire prosecution should be dismissed, she wouldn't have done her job effectively. I mean, imagine a defense attorney who concedes that the prosecution did some portions of the trial correctly. Like that's just not a thing, right?
And
Or having-
concedes. What does concede mean?
Oh, okay. So to concede would mean that you agree. And
Okay.
so if Ms. Bonjean, or Attorney Bonjean, I should say, if she did not argue that the entire thing should be thrown out, she would not be doing her job, because in essence, she would be agreeing that there are some portions of the prosecution that are absolutely correct and okay. And that is the opposite of her job, right? Her job is to say, my client is innocent, because that is the stance that R. Kelly's taking. Remember,
Right.
he's not taking the stance of, I did these things, but he's been very, very clear about believing that he is innocent of what he's being accused of.
Right. Right. So now, I don't want to go over the. Should I go over? No, the relevant facts, I believe. And the argument. Should we just go over the argument, right? That's where her points are made. The
Yeah, the
argument
argument is where her points are made. The relevant facts is just for the purpose of giving
for
the judge.
the story,
Yeah.
right?
Yep.
Okay, okay, okay. All right. So now here, she says that this court must set aside the verdict of guilt entered against the defendant and enter a judgment of acquittal, where the government presented insufficient evidence of the offense of racketeering one and all Mann Act violations, counts 2 through 9. Federal Rule of Criminal Procedure 29C provides that if the jury has returned the guilty verdict, the court may set aside the verdict and enter an acquittal. So a court can enter a judgment of acquittal on the grounds of insufficient evidence only if, after viewing the evidence in the light most favorable to the prosecution and drawing all reasonable inferences in the government's favor, it concludes no rational trier or a trier of fact could have found the defendant guilty beyond a reasonable doubt. So then she says, to sustain a conviction, the jury must have been able to find each of the essential elements of the crime beyond a reasonable doubt. Then she case cited a law, and she said, as set out in detail below, defendant's RICO conviction cannot stand where the government failed to prove the existence of an enterprise, the activities of which affected interstate commerce and a pattern of racketeering activity. Moreover, insufficient evidence existed to prove each and every element of the charged Mann Act violations by proof beyond a reasonable doubt. So,
Yes.
that's a lot for me anyway.
It is. And before I break it down and put it in layman's terms, I have to say hello to Take R. Kelly, Give Us Back Tupac. I have to say
Oh, my girl's in the building. What's up, Take?
and hello to Karen A, and hello to OCOV Fat Boy.
Oh, my fat boy's in the building. What's up, puppy?
Absolutely have to say hello to those folks. But now, let's hop into what she's saying here, because it sounds like a lot of gobbledygook when you read it. But
Right.
in essence, what she's saying to the judge is, listen, Your Honor, I know that he was found guilty by a jury. That's the trier of fact, the fact finder, right? So she's saying, okay, I know that he was found guilty, but we think that that was wrong. We think that the prosecution did not present enough evidence to support that conviction. So really what she's saying is, I think the jury got it wrong. That's what she's saying.
Okay. Right, because they're the ones that put the judgment down
Exactly.
at the end of the day. So, and it's crazy how she's saying that they didn't do that when I think they, for me, I'm not a lawyer, that I'm not of the law or anything like that, but just reading the transcripts and going through everything, I feel like they proved the elements of his modus of operandi, to it detailed to where his crew, his entourage, his managers, bodyguards, and so forth, his moving parts, his squid, right, as they labeled him, having a squid for an enterprise. I feel that they proved all those elements because they had the testimonies of the girls. They also had testimonies of his ex-employees. And they also had the bad acts that were also corroborating evidence to back up the government's claims. So for me, it's crazy how she's saying that, that doesn't work. It didn't go right.
I agree with you. Now, this argument, as I said, it's kind of part of her job, right? She has to make the
She has to
argument.
do her job.
But it is not an argument that very often succeeds. I mean, it's very rarely that someone is able to successfully argue that a jury got, their verdict completely wrong. Because really, you have to, and this is going to be the part that I think is the most interesting to those who aren't familiar with the legal system. But
Okay.
really, she has to effectively argue to the judge that the judge did not do her job. Because
Mm.
there's something called jury instructions. So remember,
Right.
the judge gives
Right.
the jury instructions.
Right.
The judge instructs the jury on burden of proof. The
Right.
judge instructs the jury on, what beyond a reasonable doubt is. In this case, the judge provided instructions to the jury about what an enterprise is,
Right.
what RICO is, what racketeering is.
Right.
So really, to be successful with this motion, she would have to say, Your Honor, you did not do your job, or if she's very, very talented, Your Honor, you tried your best, but still the jury did not understand.
Well,
Because
she is blaming this on the jury too. You
right,
know that?
right.
She's saying that the jury too there was an ineffective voir dire.
Uh-huh. Uh-huh. And again, she is low-key arguing the judge did not do her job because again,
Right.
who's presiding over voir dire, right? The
Right.
judge is. And so if something happened that was inappropriate at that time, I'm sure the argument was made at that time. And that means that the judge ruled on whatever that argument was back then. So, as I said, it's a very nuanced argument to make. And that is why you're rarely ever successful. This type of motion is only ever successful, at least from what I've seen, when you have a case in which even the judge thinks, oh, something went wrong. So, for example, if you have a case with breaking and entering,
Right.
and they have a video of this person breaking into the home,
Right.
but then the jury finds that person not guilty. That's the kind of case that, when the prosecution files their motion and says, Your Honor, we think the jury got it wrong. That
Right.
is the kind of rare case in which a judge will actually say, oh, you know what? Something went wrong here. I do think the jury got it wrong. It very rarely happens.
Mm. Mm. So it's wild. Because she's like in here, she's not really, I mean, I guess she is saying the judge didn't do her job, but she's more pointing at the jury and his ineffective counsel.
Mhm. Which she can do. Remember, she can make the argument that the jury just did not understand. For some reason, whatever decision they came to
Right.
doesn't agree with the evidence. She can make that argument.
Right.
But as I said, what's underlying that argument is the judge. That's underneath that argument because
Right.
the judge is the entity that is supposed to explain these things to the jury and bring
Right.
it to a place where they understand it.
Right. It's her court. Everything's under her rules and she oversees the case.
Exactly.
Right. 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 So at the end of the day, it kind of like falls on her ass at the end of the day.
There you go. At the end of the day, it falls on her. So of course,
Ah.
Bonjour is going to say, "Oh, the jury did not reach the right decision."
Right.
But and to the layman's person, it reads that way, right? But to
Right.
someone who is a practicing attorney, to someone who knows the legal world,
Right.
and to other attorneys, we get that she's low key saying, "You are right." We get what she's actually saying. Because it's the
Right.
judge. Right. So she's kind of, and truth be told, as I said, these motions are rarely ever granted. So remember, the purpose of this motion is not because she actually thinks that Judge Donnelly will grant it. The purpose of this motion is for other judges because she's going to appeal something else, right?
Right.
And this may go to a higher court. She may ask a higher court to look at this.
Right.
So that's why it's important when I say we get what she's saying. When a higher court reviews this, they will get what I got. They'll get that she's low-key saying Judge Donnelly made a mistake, and they'll review everything Judge Donnelly did.
And I have another question. Does once Judge Donnelly denies these motions, right? Because she hasn't denied them yet. there's still another chance that the government now can come back, and she could come back. The government can come back, and then she got one more chance to come back until April. I forgot what date. April 22nd or 19th, something like that. They have a chance to come back to rebut all of this stuff, because this was Bonjean's motion for the acquittal, which is motion for Rule 29, right? Or something like that.
That sounds familiar.
Right? Rule 29, I believe it is. So it's Rule 29 for this one. And then she had put in a motion for Rule 33, which is a new trial. So the government did come back, and they gave a response to these two motions, and they're asking the courts to deny it, of course, as we know.
Of course.
And yeah, so now we're waiting. No, then Bonjean just came back yesterday or the day before with her rebuttal to the government. And that's when she also asked for the new sentencing to be pushed. She asked for the sentencing to be pushed. So now we're waiting for the government to come back with their rebuttal. And they have until the 19th, I believe. Yeah. So now, when all of this happens, so after all this happens, Miss Esquire, and Judge Donnelly says, deny, now what would be the next step? Because we heard that it would be that Bonjean could either go to the circuit court, or she could go straight to the Supreme Court, because there's some type of order or something that says that he could go straight to the Supreme Court.
Well, I don't know if there is a specific order in this case in regards to whether or not they could go directly to the Supreme Court. But what I do know is that if they try to go to the higher court, so if they try to go to the circuit court after this, right, and that doesn't work, or rather I should say the appeals court, but every district is different. That's the next thing.
Right.
Every district has their own court hierarchy.
Yes.
So
yes.
Note that when we say circuit court or appeals court, we just mean next level, right?
Right.
Next level. So we know that she can appeal to the next level, to the next highest court. And we know that if that doesn't work, she always has the option of filing a petition for writ of certiorari to the Supreme Court.
Oh, writ. A writ. Right. There you go. That's what it is, a writ.
Now, I recently talked about these writs on my page, on my channel, because we were discussing, what case did it come up in? Darn. I can't remember what case.
I think it was when you were talking about the guy, not Polite, not the damn, there was a guy that you were talking about after Polite. Shit.
Fine too, right? But is it Bill Cosby?
Were you talking about Bill Cosby and it was with a writ?
We were discussing someone, anywho, and I explained to them, listen, one of the ways that you can have the Supreme Court review your case is to submit a petition for writ of certiorari.
Right, writ of damn, who were you talking about? Damn, I forgot who it was too.
Who I was talking about. However, what I explained to them, and what I'll share with your audience as well, these petitions are not often granted. And when I say not often granted, I mean the Supreme Court receives about 7,000 petitions per quarter. So
yes,
right, and they only accept about 80 out of 7,000. So yes, they will have the option of filing a petition for writ of certiorari to the Supreme Court like everyone else, but their chances of actually getting that petition granted is very low, and I'm going to tell you why. Not just because of the numbers, but also because when the Supreme Court does accept a case, they want a case that speaks to a very specific issue, because they want to set precedent. Precedent, which is the fancy word for case law, right? They want to make new monumental decisions. So they are looking specifically for cases that give them the opportunity to do that. So
guys, excuse me.
Go ahead.
Excuse me. I'm sorry to interrupt you.
Yes.
Exclusive news. A something just came in from Bone Jean. She just put in something else, guys. I'm gonna bring it up. Give me 1 second. You can continue, Miss Esquire. I'm gonna go on mute.
No, that's fine. So, for example, something really nuanced and monumental, like the Supreme Court DACA case, right? Where you had the Supreme Court deciding if DACA status is constitutional, right? If it's constitutional to grant someone a temporary status based on the age that they were when they entered this country, right? Or something like Roe v. Wade, where you have the Supreme Court deciding if it is constitutional to decide whether or not a woman can terminate something that's ongoing within her uterus. So that's the kind of case the Supreme Court is looking for. Here we have a man who was accused of human trafficking. I try not to say certain words, but accused of RICO and other things like that. And yes, to his fans, it may be really monumental, but the Supreme Court will be looking at this case and wondering, well, where in this case do we have the opportunity to make precedent here, to make, new case law? And I really don't see that here. I don't see that here, but I will say this. If his attorneys can effectively carve out a niche that will interest the Supreme Court, they can increase their chances. And although at the outset, it's not that obvious, there is a niche here. I'm not going to say it because I don't want to give them ideas. And I know these attorneys listen to these lives. So I don't want to give his attorneys ideas, but there is a niche there. There's a question there that I literally just thought of, and I thought that could be good. So if they can effectively carve out the question that the Supreme Court can make precedent with, then they'll have a shot.
Not you, Miss Esquire. Sorry.
Oh, no, I'm fine. I'm done. I'm not going to say what they should say because I don't want to give them ideas. People had always told me that, these attorneys are listening to these lives and things like that, and I didn't believe them. But I'll tell you, very recently, not with R. Kelly, but with another issue, I saw a talking point from my channel regurgitated somewhere else, and I realized, oh, people do listen. So I am not going to say what Bonjean should be saying if she wants the Supreme Court to look at it, but there's a question in there. There's a question in there that if they pull out that question, if they're insightful enough to pull out that question, they might have a chance at the Supreme Court.
Wow. They are watching us, Miss Esquire. You're absolutely correct about that. They are watching us. So, now, so she's trying to acquit everything, right? So, oh, my glasses. I'm behind the scenes dealing with kids and food and everything else, guys. So bear with me. Okay. All right. So now she wants to get rid of the whole entire thing, which I doubt. Of course, I don't think it's going to happen. I don't. Now I'm trying to remember if this was, let me go back to the actual, I'm going off the screen, guys, so I'm not going to see you guys in the chat. Okay. All right. So in this part, she's talking about Racketeering Act 1, which was the bribery with the whole thing with Aaliyah, right? And here she says that this court must acquit defendant of the offense of racketeering where the government failed to prove defendant guilty beyond a reasonable doubt of each and every element of the offense. The government effectively swamped the jury with bad character evidence that was guaranteed to produce a guilty verdict, but its proofs on the charged offenses were insufficient as a matter of law.
Interesting. Okay,
I knew you were going to find that interesting.
Listen, so I give credit where credit is due, and let me say this.
Of course, baby.
And some people are going to get
lawyer to lawyer, of course.
Right, and some people are going to get upset with this, but let me say this. Everyone has the constitutional right to an attorney.
Of course.
So I discourage people being upset with the people who are representing R. Kelly. right? He
Right.
has the constitutional right to an attorney. He's
Right.
got
She's
to
got
pay
to do her
somebody
job.
to do it. So it might as well be someone that is actually, deserving of it, right?
Right.
And
Right.
so Bonjean is definitely earning her check. I mean, whether
Wow.
you agree with it or not, she's earning the check.
Mhm.
So what she's saying here is you said things, or I shouldn't say you. Let me, because I'm trying to break it down for you. So what
Yeah.
she's saying is, Judge, the jury was confused. The jury was confused because prosecution presented all this evidence that made my client look like a bad person. And so, because the prosecution made R. Kelly look like a bad person, the
Mm.
jury just got so confused and they got so upset by him being a bad person that they convicted him because they didn't like him. Not because, yeah, you see why I said she earned the check?
Wow. She's
Not because
Chacho.
he's guilty.
She's definitely doing her job. And I say it all the time. She's just doing her job. Whether she wins or lose, she actually tweeted it out. She had tweeted something out, and then one of our girls, Shorty Rah Rah, you in the building, we love you. One of our girls replied to her tweet and had made the comment like, well, we all know he's guilty, and good luck with what you're trying to do. It's not gonna work. And she was like, at the end of the day, I'm just paraphrasing. And then she says something to the effect of, well, I'm just doing my job and I can't promise anything to anybody, but I can promise you that I'm trying my best.
Right. That's what she should be doing. She should be trying her best. And this is a good argument because what she's saying is the jury, as I said, was confused by their dislike of
Right.
art.
Right. And I think why she's saying that is because the whole thing with the voir dire, that some of the jurors were questioned if they saw the documentary, if they knew about his problems. And some of them mentioned Jeffrey Epstein. They mentioned about R. Kelly, that they know that he don't like, that he's into minor little girls. That one of them even compared him to Jeffrey Epstein. Um, and a couple of them said that they watched the documentary. One said that she'll try to be as como se dice, as fair as possible. It was just like crazy what the jurors were saying. We were like, wait a minute. Why would she let that person in? But then come to find out that when a voir dire, both sides get to question everybody. So if they had a problem or an issue with that process and the person, and they wanted to get rid of them for just cause, they could have done that right then and there. So she's saying that the judge should have done something about that instead of letting that go on.
What is she saying shouldn't have happened? Because both sides had the opportunity, just as you were saying, in voir dire or voir dire. Some people say voir dire, some people say voir dire.
Yeah,
Um,
right.
in voir dire, as you said, both sides have the right to question jurors. Both
Right.
sides have a certain number of strikes that they
Right.
don't even have to give a reason for, right?
Right.
So that is how it should have happened, that both sides should be questioning, both sides should be striking someone they don't agree with. That is the normal course of business. Now, someone noted in the chat that R. Kelly had written some letter saying that, he did not get to participate in jury selection.
Yes, I'm about to pull up that up right now while you're talking, because that's exactly what I'm doing in the background.
Right.
Girl.
And so here's the thing about that. So possibly, a higher court could look at that and they could say, I think that because R. Kelly did not have a say in jury selection, this case is tainted, right? A higher court could say that. However, comma, in the world of legal representation, there's something called legal strategy or litigation strategy. And so it's understood that your attorney, to a certain extent, can make decisions that you don't like if they have a strategy. It's only to a certain extent, mind you. So, yes, a higher court could look at that and they could say it was unfair that R. Kelly did not get to this or that. But on a whole, something like jury selection is really considered to be in the realm of an attorney's litigation strategy. And so, as long as his attorneys can effectively articulate why they did not listen to whatever it is he wanted them to do, they should be fine. They should be totally fine. Now, as far as the documentary and whether or not that taints a juror, if a juror answered no, so if they asked the juror, did you see the documentary? And that juror said no, and they could later on prove that that juror was lying, that would be grounds for this trial to be totally thrown out. And I'm going to tell you why. That documentary is extremely incriminating. I don't know a person with an actual brain in their head that will watch that documentary and not come away from it thinking that R. Kelly is guilty.
Right.
So, yes, if a juror did not disclose that they watched that documentary, if they say no, they were selected, and then we now find out that they did watch that documentary, that would be a big problem.
Now, that's crazy because, oh, wait, what is this one? Oh, okay. They did say, they did ask them that questions, and they did say that they did watch it.
Right. So as long as they disclose, that's fine, right? Because
Right.
you were saying, Diva, what happens after someone discloses? So yes, I did watch it. Then the follow-up question is, okay, well, do you think that you could put that to the side and be
fair.
impartial and be fair? And
Right.
oh, that's totally fine. The issue would be if they said they didn't watch it. I don't think there's an issue with them disclosing, yes, I watched it, and saying I still think I could be fair.
Right.
Yeah.
Right.
Issue.
That's what I was saying too. I'm like,
if they did not disclose that they watched it.
Right. I'm like, they were being honest. And then they were asked after that, do you think it could be fair? Yes, I could be fair. I think I could be fair. Maybe. Now, if they said maybe, could that be an issue?
Maybe could be an issue. It should be a clear, yes, I can be fair.
How
Maybe,
about I can try?
Now this comes into, again, litigation strategy. Personally, if I were the prosecution and someone said they saw the documentary, right? And then I said, do you think you can be fair? And they said, oh, maybe, or I can try. I want that juror. Obviously, they don't like him. And as I said, someone with a brain, you can't see that documentary and think that he's a great person, right? But again, where was the defense counsel? Because that's a juror that they should have struck.
Right.
Are you asleep at the wheel? Because that if that person is saying maybe or I can try, defense should be jumping to get rid of that person.
Okay, I'm trying to get the other document up. All right, where is it? What did I do that? No, this is the one. All right. Well, let's check this one out real quick, Miss Esquire. I don't know if you guys can. Is it showing on my screen now? I think it is. Let me double check. Hold on. Okay, yes, it's showing. Awesome. All right. Now this just came in, Miss Esquire. So let's see what Bonjean has to say. Oh, here we go. Gotta go this way. Okay. So as you can see, it says April 5th, 2022. It is to Judge Donnelly. And it says, defendant respectfully submits this letter requesting that this court reconsider its order denying defendant's motion to adjourn his sentencing hearing where defendant was not afforded the opportunity to reply to the government's letter filed only yesterday. Even if this court declines to reconsider its order, defendant files this letter to ensure that the record adequately reflects his objections to the government's position. Undersigned counsel received defendant's probation sentence report, PSR. That's what they're waiting for. There you go, the PSR. Today, that reflects the probation's view that defendant is eligible for a sentence of imprisonment of life. Apart from a sentence of death, defendant faces the most severe sanction available in our criminal justice system. Notwithstanding the stakes, the government asks this court to prioritize the accuser's schedules over defendant's right to a fair sentencing hearing, which will invariably be compromised by his inability to speak openly and candidly to a mitigation expert as another massive federal prosecution looms. The government scoffs at the notion that defendant would say anything to a potential mitigation expert that would incriminate him in the NDIL matter, which is the Northern District of Illinois, suggesting that undersigned counsel's concerns are disingenuous. The government knows or should know that any statement made by a defendant, even statements that are seemingly exculpatory, implicate Fifth Amendment concerns. See, and she's a case law, and it says that in that case law, it cites that by incriminating response, we refer to any response, whether inculpatory or exculpatory, that the prosecution may seek to introduce at trial. Now, the government finds or fiends incredulity, knowing full well that at defendant's trial, it did not hesitate to introduce statement evidence and argue the most nefarious inferences therefrom. In short, it is not quite as simple as choosing not to incriminate oneself. The risk of inadvertent self-incrimination is particularly high, where defendant's entire life must be explored. After all, the prosecution of defendant was an unrelenting attack on his life, his character, and his habits for over 25 years. Oh, wait a minute, hold up. Did she say habits? Oh my God. Okay. As a reminder, mitigation explores the whys of a case and involves the presentation of information that explains inter alia why a defendant is unique and why he behaved in a particular manner. Because the prosecution's argument in aggravation will focus on a quarter century of defendant's life, a mitigation expert will have no choice but to ask defendant inmate questions about every aspect of his life, including matters that are relevant to pending litigation. It is naive to conclude that defendant can freely and meaningfully participate in that process without potentially prejudicing himself in his pending NDIL case. Defendant is his best source of mitigation. Wait a minute. But he will be hamstrung if his sentencing hearing is conducted before resolution of the NDIL case, where this court has already agreed to adjourn the hearing until June 16th. It seems a small act to continue sentencing an additional 8 weeks to ensure that defendant is afforded every constitutional safeguard to which he is entitled. It's only his life on the line. As for undersigned counsel's competing professional obligations, the trio of AUSAs, oh no, she damn, assigned to this case are not exactly in a position to appreciate the unique burdens, guys, of private attorneys who run small firms. Wow. Undersigned counsel is entirely capable of handling more than one matter at a time and routinely does. But she is commencing a jury trial in Los Angeles on May 23rd, 2022. That will last at least 2 weeks. At the time undersigned counsel filed her appearance in this case, there was a team of defense attorneys poised to handle defendant's sentencing hearing. For reasons that only became apparent after reading the troubling record in this case, those attorneys were forced to withdraw, leaving undersigned counsel alone to handle all aspects of the litigation. And with that said, undersigned counsel has no conflict with the June 16, 2022 sentencing date, assuming her trial does not last longer than expected. However, undersigned counsel's concerns remain that defendant faces a Hobson's choice of risking his Fifth Amendment privileges in favor of fully and meaningfully participating in an interview with the mitigation expert, or foregoing that process and cheating himself of fulsome mitigation evidence that could be valuable to this court in fashioning an appropriate sentence for the defendant. Accordingly, defendant respectfully asks this court to reconsider its order. Girl, what do you think of that one?
So again, like I said, she earns her check, you know. But let me break down what she was saying about the posts. The sometimes it's called a PRS, okay, but here's what it is, by the way, if you don't know what it is. So there we go, the probation sentence report. So this is a report that is provided to the judge. It is actually completed by a totally separate entity, and it's provided to the judge, and it's supposed to guide the judge in their decision as to, you know, what an appropriate sentence would be for that defendant. Now, with that being said, that report is a very, very inclusive report. It talks about the defendant's entire life, pretty much.
Really?
The mitigation expert, they ask the defendant if the defendant ever had abuse in their childhood or in their early life. They ask the defendant about any past criminal history. They ask the defendant about any past mental health history. They ask the defendant about any past incarceration. They ask a lot of questions that could evoke an answer that is incriminatory. That is absolutely true.
Do they even ask him about like his, even though he's not guilty, but you know, do they ask him about his charges? You know, like interrogate him, investigate him, or you know, of that nature as well?
They don't specifically ask about the charges, but as she's arguing and as she's saying, you know, effectively, the questions that they ask in relation to his history could evoke an answer that is incriminatory. So, for example, when you talk about someone's history and their childhood and whether or not they were abused, right?
Mm-hmm.
He may say in this interview, you know, I was abused as a child, and you know, and as a child, I saw, you know, my parent with people that were underage or something.
Or
like
he was touched himself.
There you go. There you go. And so saying that may either lead him to say something else that's incriminating, or it could bolster past arguments as far as why he allegedly did what he did in this case. So I think she is correct in saying that he could say something. And you have to remember that this is a very unique instance, y'all. It's not every day that somebody has two separate trials in two separate federal districts. You know, usually you have your one trial, you're found guilty, they do your PSR, and then they sentence you. Done. But in this case, he has another trial, so they have to consider how this trial is going to affect that one.
Now, the government was saying that, well, listen, if it's such a big deal to you, I'm, paraphrasing. If it's such a big deal to you, then we can have that PSR under seal.
So here's the thing about having this under seal.
Okay.
This is something that a lot of people don't know, right? Under seal applies to people outside. So if you seal this PSR and whatever sentencing, right? It's sealed to the public. It's sealed to the public. Okay.
Right.
So yeah, a juror in the next case can't see it. But that does not mean that the prosecution and the judge in this other case cannot see that report, because believe me, they can get it unsealed for them.
Right. So just like certain media
jurors, but you cannot keep it from them.
So even with it under sealed, they can still get it. But another thing that the government had argued about that was that that they won't be crossing over information with the Northern District of Illinois. So they wouldn't even know about what's going on.
Who said that?
The government.
They said that they would not be giving information to that. They said that?
Yeah, I'm going to pull up the document. Hold on. Let me get it up.
I don't think they should have said that. I don't think they should have said that. I think that's disingenuous.
Yeah, I think this is it here. Was this what it? Wait, is this the? Wait. Right, to adjourn sentencing. Yeah, okay, this was the one. All right, so here they responded to the motion, the 279 motion, which is the new trial, the new trial one, right? Now, the government specifically submits this letter. Oh no, it's for the sentencing one. March 29, 2022 motion to adjourn the sentencing in the above captioned matter. The defendant, Robert Kelly, is currently scheduled to be sentenced on May 4th of 2022. The court set the sentencing date on September 27th of 2021. That's when he got convicted, right? Then the date, the jury found the defendant guilty on all counts. So the defendant's current counsel, Ms. Bonjean, entered her notice of appearance approximately 1 month later on October 29th of 2021. In her motion, defense counsel seeks an adjournment of the sentencing until the date after the defendant's trial in the Northern District of Illinois, which is currently scheduled to commence on August 1st, primarily because she claims she cannot otherwise adequately protect Mr. Kelly's constitutional rights at sentencing in this case without compromising his Fifth Amendment rights in the NDIL case. Then, even assuming arguendo that is so, there are other ways to effectively address defense counsel's stated concern that she cannot advise Mr. Kelly to be examined or interviewed by a mitigation expert for sentencing in this case if his words might be used against him in some manner in his pending NDIL trial. As an initial matter, given that the defendant has essentially challenged every aspect of his conviction as set forth in his post trial motions, and likely also intends to appeal his conviction should his post trial motions prove unsuccessful, it strains credulity that the defendant would say anything to potential mitigation experts that would incriminate him in the NDIL matter, to the extent the defendant intends to appropriately highlight his own background and characteristics, as you said, right? As Section 3553. Factors the court should consider at sentencing and mitigation. He can do so and surely intends to do so without admitting his guilt given his likely appeal. In addition, this speculative concern can be entirely ameliorated by adopting the following procedure to the extent that the defendant engages a mitigation expert. The court can permit defense counsel to file the mitigation report or relevant portions of it under seal. The undersigned assistant United States attorney, who constitute a separate prosecution team from those prosecuting the NDIL case, will not share any such mitigation report with anyone involved in the NDIL prosecution. And to the extent there is any concern in this regard, would welcome a court order further prohibiting any such disclosure.
That's BS. I know OTLV is going to be mad about that, but do y'all really believe one prosecutor's office saying that they will not give any information to the other? Y'all believe that?
I don't know. That's why I'm asking you.
No, that is total BS.
This is why we need you, Miss Esquire, please.
What they're going to do is they're going to pretend not to tell each other, Diva. They're going to pretend not to tell each other. I mean, that is just ridiculous. As you were reading it, I'm like, are they really saying this out of their mouth?
That's what I was saying. I told you they really said it, mommy. They really said it, babe.
It is the most ridiculous thing. Let me tell you, the first thing that a prosecutor does when they get a file with someone who has a case somewhere else, the first thing before they do anything else is pick up the phone and call the other office. That's the first thing they do. Hey, I see my defendant, Mr. Kelly. Right. I see he has a couple cases over there in your district. Can we talk about that? That's the first thing they do. So that to me is total foolishness that they even pretend. I mean, and I think the judge probably saw straight through that as well, because come on, not gonna tell each other? Come on.
Okay, disclosure. So then they continue to say that, nor is it accurate to suggest that there is no prejudice. Now, this is what Ms. Bonjean was just talking about in her motion, right? Saying that, nor is it, well, the government's saying this, but Ms. Bonjean was talking about hers as far as this part too. Nor is it accurate to suggest that there is no prejudice from adjourning the defendant's sentencing under the Crime Victims' Rights Act. The defendant's victims have both the right to be reasonably heard at any public proceeding in the district court involving sentencing, and the right to proceedings free from unreasonable delay. So, as proven at trial, the defendant engaged in wide-ranging and extensive criminal conduct involving multiple victims with impunity for decades. His victims have waited years to see the defendant held to account and sentenced for his crimes. Moreover, in reliance on the date set by the court in September of 2021, many victims have cleared their schedules to travel from the other states to New York to attend and be heard at May 4th, 2022 sentencing hearing. Delaying the defendant's sentencing until after his NDIL trial, which will presumably last several weeks, is not reasonable in the circumstances, particularly whereas here, the above described procedure will alleviate defense counsel's purported constitutional concern. In addition, as the court is aware, the defendant is currently housed in Brooklyn, New York. While awaiting sentencing, the United States Marshals will need to arrange for his custody transfer to NDIL prior to his trial there. Delaying his sentencing until after his NDIL trial is inefficient and will result in needless expense and delay by requiring his transfer back to this district for sentencing after the NDIL trial and then back again to the NDIL for his sentencing there. So, yeah, that's what they were saying earlier. And then Bonjean came back with the response that me and you were reading.
Right. So as I said, I think that they are being disingenuous. It's extremely disingenuous for them to insinuate that they would not share information with each other. That's ridiculous.
Right. You know, everybody says that this is supposed to be a fair trial. Now, how do you see it in your eyes? Do you feel like everybody's just trying to throw shit at the wall to see what sticks?
Yes. Yes. On both.
That's what I think on both sides too. I feel that way too, baby.
Trying to see what sticks, because here's the thing. How does it hurt the prosecution? Let's say the prosecution agreed to delay sentencing until after this next trial. How does that affect them? He's not getting released. He's still going to be in.
Right.
He will still be incarcerated.
Right.
So, and you already got your guilty verdict, and you have to do motions on your guilty verdict anyway, because you know that his attorneys have to file that motion to get it thrown out. You know you have to respond, blah, 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 and he's still incarcerated, and he will be.
Right.
So when you think about it from an impartial perspective, would it hurt the prosecution at all if they said, okay, you can delay sentencing?
Right. Now, what they were saying is that it will be violating the Child Victims' Rights Act.
And did they say how? Right? Or did they just throw that law again?
They just threw that shit in there because they didn't explain nothing.
Like when you boil your spaghetti, I don't know if you're when you boil the spaghetti, you want to see if it's finished and you throw it against the wall.
Right.
See if it'll stick.
That's,
yeah.
Yes.
Right? Because did they elaborate on how any child's rights are being infringed upon by this? He's still incarcerated.
The Rights Act, they didn't, you're right. They didn't they cited it, but they didn't explain what the violation would be.
Precisely. He's incarcerated. He's of no danger to anyone. Now, it would matter if he was getting released. If they were going to release him until he was sentenced, then of course we could probably all agree that, oh no, that's dangerous, right? Because we know that in the past, when he's been arrested and released, he's gone back to trafficking people while he was released. We know that.
Right. Now, you know that, being that you're saying that, now look, when he gets, like, say for instance, right? Let's say he gets acquitted of this, right? Or they do a new trial, right? When that happens, do they normally release the inmate?
So in this case, he would not be released, right? To my knowledge, in this case, he's incarcerated throughout that second trial, regardless, which is why I'm saying it doesn't matter.
Right. Okay, I'm glad you said that, because I'm going to say it again on my channel for the a millionth time. So if he gets acquitted in New York or he has to go for a new trial, he's not going anywhere. Why? Because he still has charges pending in Chicago. Am I right, Miss Esquire? Are we right over here?
Correct.
Okay,
Correct.
good. I don't want to repeat that shit again, Miss Esquire.
Yeah, no,
I
you
don't.
have to. He's not getting released.
He's
And
not.
even if he didn't have the case in Chicago, right, it would still be a separate argument to argue that he should be released before sentencing. And
Mm.
that's an argument that they probably would not win. I can't
Mm.
see any judge with these types of charges
Mm.
releasing someone before they sentence them when they were just found guilty. Like,
Yeah.
think about the logic there, okay?
Right. Like
So-
I had been going through Larry Nassar. Grr. And he's a predator just like R. Kelly. The only thing that I can say about Larry Nassar is that he is a true pedophile to the fullest extent of the word. Okay. R. Kelly, on the other hand, yes, he is a pedo, but he's not really so much a pedo because he doesn't really deal with what is it, adolescent children? Am I correct on that? Pedophile, right? Is for before pubescent stage, right? So R. Kelly is more or less a ephobile, a ephubile, a hebephile, and a hebephile. Ephobile, hebephile, whatever. But he's still a paraphiliac. He's still in that zone. Now, Miss Esquire, do you want to know something else crazy? In her motion, in one of Miss Bonjean's motions, she had admitted to say that R. Kelly was into coprophilia. She was like, he likes this stuff. It's nothing wrong with it. It's part of the S&M world. What do you think of her argument with that? What?
Well, I'm not sure what coprophilia is.
Girl. We looked it up over here. Mm, mm, mm. It's when a person is into the bondage and sadomasochistic stuff. And it has to do with defecation on each other and playing.
What?
Girl.
I mean, come on. How depraved do you have to be? I mean, what level have you reached where you need to do that to someone to have a good time?
Girl. She's saying that he likes to do these things, okay? The things that was on tape. Because remember, in the trial, they did show a video of one of the uncharged acts playing with urine and feces with another young lady who was there with R. Kelly. While he was masturbating, watching them play with urine and feces.
I can't.
Yep, yep. And Miss Bo Jean said, this is part of his life.
You know, I really I feel so much concern
Mm,
for the
mm,
level of depravity that some human beings are at.
mm,
And I've studied psychology a bit,
mhm,
and so something that many people don't know is the mind can be trained
mm,
to do almost anything.
That's a
And so
fact.
when you see someone who is that depraved,
Mm,
he trained his mind. Let me tell you what happened. He kept going one step further, one step
mhm.
further,
He
one step
started with
further.
the urine.
There you go. He desensitized himself. He
Yep.
trained his mind
Mhm.
to become that depraved. Nobody is naturally like that. He just kept taking one step further, one step further, one step further.
Right, to see how far you can go. Yes. Yes. And the thing is that, and these girls testified that they did not enjoy any of these acts, but they did as they were told, because if not, they would get punishments, chastised, ridiculed. So you had to do this humiliating acts as a punishment as well as an act of loyalty to him. So I'm saying the prosecutors were showing that these girls didn't want none of this stuff, but he did it to them anyway because it was a punishment. It said nothing about him and them enjoying and being consensual and kiki and ooh, daddy, ooh. That wasn't the case, according to the transcripts and testimonies. So how can Miss Bonjean even come out and say something like that, Miss Esquire?
So she can make that argument. Now, if you want to be a stickler, about it, and the prosecution could do this, by the way. The prosecution could fire back at her and they could say that she's mischaracterizing the evidence. They could call her out and they could say Miss Bonjean is not correctly stating what happened during this trial. They could say, Your Honor, we'd like you to admonish Miss Bonjean. She's taking liberties and she's reinterpreting things. And that's not what we heard during the trial. They could do that. But again, that would require them being very, very, I guess you could say zealous, right? Because again, they already got their guilty verdict. Right. So a lot of things they're probably going to let slide. Now, here's Miss Bonjean's side of the argument. She can say, well, Your Honor, I am saying what my client expresses as his experience. And she can say that. She can say, Your Honor, my client's experience was that the women that he partook in these actions with enjoyed it. And that is why I repeated it that way.
But that's
she can say that.
Right. She, like I said, she's just doing a job.
Exactly.
But it's crazy how you know, I mean, she can't deny it because there's video evidence of it. So she had to try to make it look good. I get it. But I don't think it's going to work. I said it. It's not going to work, Bojo. Sorry. It's not happening. I'm trying to look here. This is the, this was the government's response to her new trial motion. And here they were talking about the voir dire and all of that. Okay. So here, number 2, the defendant was not wait, is this, wait. This is the government. This is the government responding, right? Is that what it is? Wait, let me go check again. Right. Yeah. This is, this is right. Yeah. This is the government responding to her pursuant to Rule 33 of the Federal Rules of Criminal Procedure for a new trial. So in here, the government replied to her stuff and they broke it down. And they talk about juror number 3, number 4, number 5, number 7. So what page was that? 11. Let's go to 11 real quick and see what they said about the jurors, right? I should have just did the other thing. I went to the page. All right, number 11. Okay, all right, I guess we can start from here. Okay, here we go. Yeah, I'm gonna have to start from. I'm gonna have to start from analysis. I'm gonna do the analysis. Right now, the analysis for the government, they're breaking down the reasons, right? Is that what it is? The reasons of why they did what they did? Is that what the
Yeah.
analysis usually is?
So, right. So they're breaking down why his assistance of counsel was not ineffective. And then they're using the precedent, which is a case in which the defendant's name was Strickland,
Yeah, they're using Strickland.
to explain the standard for what makes counsel effective or ineffective. And they're using each portion of the standard, so each element, to say, hey, this is how we, or rather, how R. Kelly's team was effective in each prong, meaning that he did not have ineffective assistance of counsel. So they're just breaking it down. They're saying, listen, this is what happened. So for prong one, when they talk about trial counsel failing to conduct any meaningful voir dire, right?
Right.
Those assertions, as they're saying, are generalized assertions. So you can't just say they did not, ask the questions that I wanted to ask, or they did not ask the questions the way that I wanted them to. That doesn't equal ineffective counsel.
Okay.
That equals, again, that your counsel may have made some litigation, strategic decisions that you didn't like, but that's not ineffective counsel.
Yeah, and another thing that they were saying to her was that, listen, lady, they were like, listen, Bo Jean, we know that if anything, the reason why that your defense team decided to leave these jurors was for strategic reasons to bring this all to where we're at today. The government said that to her. They sure did. Girl.
I wonder if that's true.
Right. So if that is the case, right? This whole thing is, girl, that they're not worried about it. Because, right, if it is true that the defense did that as a strategy to work on an appeal, could they get in trouble for that? What would be the repercussions behind that, Mama?
I mean, of course you can get in trouble for that. If you have a bunch of attorneys drop out solely for the purpose of making it look like they were ineffective or there's a lack of counsel for an appeal, yeah. But how do you prove that?
Right. How do you prove that their strategy was to keep some of these jurors in so that they can later get an appeal?
Yeah, that there's no way. So similar to the hypothetical that I used with all of the attorneys dropping out and being switched around and things like that, the same hypothetical applies to the jurors. There would be no way for you to prove that unless you had a recording of unless you had a recording of Bonjean saying, okay, so we're going to keep these jurors in.
Well, actually, it wouldn't be Bonjean. It would be Canick and Scholar and Leonard and Becker.
Okay, right. So unless you had a recording of them, unless you had a recording of them saying that's their strategy, and that strategy is, to me, really ridiculous. I mean, why would I purposely keep jurors that I know could be harmful and then say that I'm retaining that for potential appeal? That just sounds ridiculous.
Right. Like they didn't say it, but the government is assuming it.
Yeah, that doesn't sound right to me. And Rocking with the Truth said, Empowered Esquire, can you define teenage adult for me?
Oh, Lord, Kadike, listen, around here, girl. We got old people.
You know what?
Old people older than me and you, mommy, talking about they are teenage adults.
You know what I think they mean? I think they mean, Diva and Rocking with the Truth?
18 and 19.
There you go. 18 and 19. That's what they mean.
That's what I said.
Teenage adults. 18 and 19.
But that's only for the ages 18 and 19. Not
Correct.
15,
Correct.
16,
Not 15 and
17. No, that's not what that means. It means 18 and 19 because they are still teens and they are also adults, but they're young adults. They're not full adults like a 21-year-old is a grown adult. Am I right?
Correct,
Right?
Amanda. Yep.
So we ain't crazy over here, people. We're not crazy over here. We're not. Okay. So there was just this whole stuff back and forth. Now, there was also a thing about um uh text messages that were now I don't remember if it's in here. I think it was in the yeah, but they didn't bring it up in the government's response. It was in the new acquittal one. Wait, let me. This one was no. This one is the acquittal. Was it in this one, guys? No, it was in the new trial one, right? It wasn't the acquittal. Was it the acquittal about the? Wait, I think it is. The acquittal was about racketeering charge. Right, guys? It was Jane's charge, right? Now the mother, now Bonjean, get this one. Bonjean had found some text messages. Yeah, I think it was this. It was this one. Bonjean had said that she found some text messages, okay, and that they should drop the charges of coercion and enticement for Jane, which is Jane Doe number 5. Coercion, enticement. I think this is it here. Okay, yeah, this is it here. Now, Bonjean found this messages between mom and her daughter while the daughter was traveling to California. Okay. Now, in the whole thing of the travel with California, this is supposedly where Azriel contracted the herpes and found out while she was in California that she went to the doctor and she found out at the doctor's office in California when she was there that she had herpes. Right? Now, Racketeering Act 8B, which is the coercion or enticement portion for Jane. The government alternately argues that defendant is guilty of the Mann Act stemming from his April trip to California because defendant knowingly persuaded, induced, enticed, or coerced Jane to travel to California. So the whole charge is about enticement and coercion and persuasion for her to travel to California, the Mann Act, right? Right? No, this one's racketeering, right? Racketeering. Coercion, which is right, the Mann Act. See, it was the Mann Act. Okay. Oh, girl, there's so much, it gets me confused. Then it's from traveling. Jane was traveling into California in April through May of 2015. So quite the opposite. The record shows that Jane's mother purposefully and strategically enticed defendant with her 17-year-old daughter, comparing her to Aaliyah at various points. So GX233. That is, the government takes great umbrage to this characterization, but the record speaks for itself. Then Bonjean continues to say, although defense counsel did not make much use out of it, Government's Exhibit 233 offers powerful evidence showing that defendant had no reason to induce, persuade, entice, or coerce Jane into going to California with him. Text messages introduced by the government show that Jane with the guidance of her mother, enticed defendant who reasonably believed Jane was 18 years old to bring her to California. So, in short, when Jane traveled to meet defendant in California in April through May, she required no enticement, persuasion, or encouragement of any kind. So on April 11, 2015, Jane attended one of the defendant's concerts in Orlando, Florida. After the show, someone provided Jane with the defendant's phone number. Jane attempted to text the number on the phone and gave the paper to her mother. Although Jane did not reach defendant, Jane's mother began texting the defendant, posing as her 17-year-old daughter. Jane eventually communicated directly with the defendant via FaceTime and told the defendant she was 18 years of age. On April 20th of 2015, Jane's mother, still posing as Jane, initiated text messages with defendant and arranged for Jane to meet the defendant at a hotel in Orlando. So, Government's Exhibit 233 shows that Jane and her mother knew from the start that defendant was interested in Jane sexually, believing that she was of legally consenting age. Before Jane's first meeting with defendant, Jane's mother texts Jane stating, and I'm a quote, "This man trying to screw, but I'm trying to make it business. He knows you're a singer, but he ain't playing. He wanna fuck tonight." Despite that, Jane and her mother were on notice that defendant was interested in Jane sexually. Jane's mother encouraged Jane to meet the defendant. She told Jane to keep defendant's curiosity piqued and advised her about what she should wear to effectively entice him. During her in-court testimony, Jane testified that she went to meet defendant solely to audition for him. But her contemporaneous text messages reveal that Jane was more interested in defendant for personal and romantic reasons. Jane texts her mother, he's so fine." When Jane's mother told her to be ready to sing something, Jane said, "Ugh," suggesting that she did not actually want to audition for a defendant. Jane's mother encouraged Jane to tease defendant, but not to do anything sexual with him, since he would then lose interest in her, believing that he was speaking to an 18-year-old Jane. Defendant texts Jane's mother that he was staying on the tour bus, but was going to get a hotel room for their privacy. Jane's mother then shared that message with Jane, texting, "Yup, he said he's staying on the tour bus, but he wants to get a hotel room for just y'all, so y'all can get away from security and managers, etc." Jane's mother gave Jane some final advice before she sent daughter to meet defendant, who believed Jane was 18 years old. "Be prepared." This is what the mother said to the daughter. Be prepared to sing 3 songs. He said he will meet you and listen to your song. Please have your glasses off, hair to the side, mama knows best, pretty hurts, and third, your choice. Don't yell, put on a show, dance, grab his hand, shimmy, wiggle, sit on his lap, entice him while singing. It's all about performance. This, your chance and opportunity. Don't blow it. Jane's mother even told Jane not to look grown. Then she says, the mother says, take off that ugly ass. Excuse me. I gotta get some water. Take off that ugly ass lipstick. I told you he didn't want you to be grown. I told you to keep hair curly. That shit looks a mess. You need some jeans or shorts. You're trying to look grown. He wanted you because you look young and innocent. That's what he wants, not a little girl trying to be grown. You're a damn fool. Then it continues to say, Miss Bonjean says, defying her mother's advice to merely tease defendant. Jane engaged in sexual conduct with defendant in the hotel room. Jane stripped down to her undergarments and walked back and forth for defendant. She later acquiesced to removing her clothes, testifying that she got on top of him backwards and he licked my butt. After the sexual encounter, officers arrived at the hotel room and knocked on the door. After arranging for Jane to meet defendant in hotel room, Jane's parents apparently called the police. Jane described defendant as nervous and anxious, asking her to confirm that she was 18 years old and she had represented. Jane testified at trial. After he, which is the defendant, looked through the peephole, he made me go, this is what she said, he made me go into the restroom immediately and told me to get dressed. And he said, are you 18? And I said, yes. And he said, don't lie to me. And I said, yes. The defendant opened the door and the police checked Jane's identification to confirm her age before leaving. Defendant was present when police officers checked Jane's identification. Rather than calling it a night, Jane again removed her clothes and got on top of defendant to continue their sexual activities. After her first encounter with defendant, Jane told her mother that defendant had asked whether he could fly her to meet him. And Jane told her mother, I said, duh. Jane continued to communicate with the defendant via text message and by phone and continued to spend time with the defendant in Orlando, doing normal dating activities such as seeing movies and eating out. And she cites the exhibit GX233. At one point, Jane's mother got frustrated with Jane for not prioritizing her music with the defendant. On April 23rd, 2015, Jane's mother texts her, you need to let him hear your songs. Let him see your video. You're trying to date the man you need to let him see your shit. Jane's mother also continued to encourage Jane's relationship with the defendant, telling her to be a little feisty, stating, he married Aaliyah because she was feisty. She didn't let him run over her. You need to be different than the rest. Later that evening, Jane's mother texts Jane, you are silly. That man ain't trying to do nothing with you musically. He wants to fuck, period, because he likes young girls. Jane reassured her mother that the defendant was willing to look at her performances and was patiently waiting to look at some of her videos that her mother had emailed her. On April 24th, 2015, after the defendant had left Orlando, Jane's mother instructed Jane, you better be texting him so he will stay on your mind. So you will stay on his mind. Later that day, Jane texted her mother about flying out to see the defendant in California. Jane says, and I talked to R. Kelly. Mom says, yeah, about what? Jane said, laughing my ass off about flying me out. Mom says, oh, really? When? Jane says, yeah, whenever I tell him he can. Tomorrow if I choose. Mom says, oh, yeah? Then on April 28, 2015, Jane traveled to Los Angeles, California to meet the defendant with knowledge and consent of her parents. Jane continued to text with her mother once in Los Angeles. At one point, her mother told her he going to be in your room butt naked with one of his songs playing, laugh out loud. Government's Exhibit 233 reflects that Jane and her mother text insistently with, while Jane was in Los Angeles with defendant. Jane tells her mother at one point, crazy, this Aaliyah movie just came on and I just got off the phone with Mr. R. Mom responded, really crazy. Jane testified that she had oral sex with defendant in Los Angeles, but she did not share that information with her mother via text. At no point did Jane express any apprehensions about being with defendant or ask her mother to arrange for her to come home. When Jane excitedly told her mother that she was riding defendant's tour bus to Stockton to attend this concert, Jane's mother responded, "Oh my God, exciting. You're riding on the tour bus." On May 1st, 2015, Jane's mother urged Jane to take advantage of the defendant, texting her, and I quote, "It won't be star lifestyle if you don't get serious about your music and show this man you want to be famous like him. Once he's tired of you, you'll be like everybody else. You better use this as your opportunity while you got him in a spell." Jane's mother then said, "You should text him and be like, you're going to be my boo and see what he say." To which Jane responded, laughing my ass off. Jane traveled independently to meet the defendant in Stockton, California, where he was performing on May 1st, 2015. She stayed in contact with her mother the entire time. At one point, Jane explained to her mother how she ended up going to Stockton to see the defendant's performance. And she says, I quote, "I told you. He asked me, did I want to come to his show? I said, of course. And he said, okay, then let's pack this stuff up. He was even putting his stuff in my bag." Jane and her mother remained in constant communication before defendant's show. Jane's mother instructed her about what to wear and made suggestions about how she should behave at the defendant's show. She says, and I quote, "I would blow him little kisses and wink at him and bite the tip of my finger, mess with him real good, do something seductive, then make a silly face, laugh out loud." Jane and her mother continued to text throughout defendant's performance. At one point, Jane and her mother exchanged the following texts. Jane says, "He's singing the whole show to me." Mom says, "Laugh out loud, too funny." Jane says, "FR," meaning for real. Then Jane says, "Laughing my ass off." Then Jane says, "This man's in love." Then Mom says, "Oh my God, you gonna marry him and have his babies?" Then Mom says, "Laugh out loud. My son-in-law gonna be older than me." Then the mom says, "Too dang funny." Then Jane says, "Laughing my ass off." Then Mom says, "Well, you better get signed first, then married second." Then Mom says, "He's going to seduce you tonight." Jane says, laugh out loud. Mom says, "You have to give him a massage before he go to bed." Jane says, laughing my ass off, "No, I doubt it." And then Mom says to her, "Girl, you better, or he will get someone else to." What do you think of all of that?
That's a lot.
Girl.
A whole lot. So here's the thing. My only question is, what did her identification say? Did her identification say that she was 18? Was
17.
it a fake? 17. Okay. So when they checked her ID, they saw that she was not 18.
So you think they did. But when they did this, mind you, as they looked at her ID, verified her shit, gave it back to her, then they gave them a business card to Art Kelly and said, "Listen, if you need any security, call me, okay? Bye."
Right. So R. Kelly was present when they checked her ID and they saw what age she was.
Right.
Okay. So uh all of that was of course very disheartening, right? Because you can tell that the mother was encouraging it.
Yes.
Again, legally, it's irrelevant.
Yes.
And I can
Yes.
understand
Yes. I knew it.
legally it's
I knew
irrelevant.
it.
And I can understand why the defense would want you to read it, right? Because it sounds terrible.
It really
It
is.
really
It
sounds
really
like
is. I wouldn't even be joking with my daughter like that. Word up.
right. It sounds like they plan to entrap R. Kelly, right?
Yes,
It
they
sounds
did.
awful. But at the end of the day, R. Kelly knew she was a minor. Although
Ah.
she at one point lied about her age, he then became aware of her real age. And
Pow.
after finding out her real age, he continued. As I've said on
Pow.
your show before, I don't care if someone's mother walks them into the room naked. The
Pow.
grown man who is in that room is responsible for ending the interaction.
Pow.
And
Pow.
if he
Pow.
doesn't, when he knows that that person is a minor, he is still criminally responsible. He's still guilty.
Guilty. Guilty. Miss Esquire, we've been screaming that shit over here for like I don't know how long now. And we're still screaming it. Okay. And Miss Esquire verified it for us over here. Again, we are definitely for sure, we know that it does not matter. The guy who also talked about this, the lawyer, the other lawyer, he said the same thing. So, can we please enough with this goddamn text messages already? That's all I want to know.
I want to say that someone in the chat says they didn't look at the months, they only looked at the year. And whose fault is that? Well, let me let y'all know right now. If you're about to have an interaction with someone and they
I'm gonna
hand
stop
you
sharing. Now we're gonna take questions because we're done with all this shit.
okay, yeah. If you're about to have an interaction with someone and they hand you their ID and you choose to only look at the year and not the month, you still going to jail. Okay, let's be clear.
Exactly. There is no he's not getting out, even if he gets acquitted, even if they get a new trial, he's not getting out. He's got to go back to Chicago, no matter what. He's got to sit his ass a little bit longer. Okay. Another thing, these texts, even though we know that it looks bad, we know what the mom did. We feel the way we do, OCOV over here, about mom and her damn antics with her daughter. Okay. We know that these things are true. These are real texts. This was actually submitted in evidence that was taken and extracted out of Azriel's phone. So let's leave that right there. I'm not going to talk about this shit anymore. I'm not. I'm telling you right now. I feel the way I do about those parents. We stood up for them and now we feel duped. That's it. That's all. We are not here and never were here really to support the parents. We are here for the victims, period. We supported the parents because they're their parents. But at the end of the day, we're here for the girls. We're not there for them. So we feel the way we do. Those who want to believe that the Clarys are all white and right, that's you. I'm not mad at you. I should pray that you ain't mad at me and we can continue and be as we be. Okay? Because we shouldn't be mad at each other over that bullshit. We should all be here for support of the victims, regardless of what we think about the parents. Okay? So I'm going to say that, and I am not going to go over this shit anymore. Miss Esquire was the last resource and confirmation that I'm making, and that's it. It is stamped, sealed, and mofo delivered. Ya se acabó. End the story. So now that we all understand that and got that clear out the way, I'm going to go through some of your comments and put them on the screen. I'm also going to drop the link and we're going to just come on and ask Miss Esquire some questions. If you want to personally ask her questions, avatar to avatar, then we are going to do that. All right, y'all? So anybody who would like to come up, I just dropped the link. Come on up and drop your knowledge. So Miss Esquire, yeah, so that's all the drama that's been going on over here since you've been so busy, my lady.
Yeah, per usual, people getting distracted by things that don't matter. Is the mom the best mom in the world? Probably not.
Right.
That's not legally significant. And what I can't understand is why people don't get that. I can't understand why adults don't understand that even if someone tries to sell you their child, you are still wrong if you buy the child.
Right.
Why is that something people don't grasp?
I don't get it, Miss Esquire. Okay, they have this groupie fanatic stuff, man. Like it's just groupie stuff. It's goofy groupie stuff. Like you these people would actually travel around the world to follow R. Kelly. Real groupie shit. That's all it is, Miss Esquire. Real groupie stuff. It's crazy. Like I say, R. Kelly, I feel bad for him. I would never want none of these people as my supporters. Oh my God. Like they've heard his case so much. They are the reason why. Well, one of the reasons. They are one of the reasons why they had a partial, what was it, anonymous sequestered jury. Like, because these people are crazy. They attack your mother, your father, your sister, your job. They dox your businesses. They come and pop up at your businesses. Do you know that one of these bloggers actually went to one of the victims' jobs?
I'm not surprised. And that's the kind of behavior that can get that's the kind of behavior that can actually result in something happening with a trial. Like that's the kind of behavior that can have an entire trial ordered as a mistrial.
Wow. And look at that. Because of those actions, the action of the stalking the young lady at her job and the calling and the doxing of certain of the girls' businesses and stuff like that, and also intimidating them online is a reason why he had an anonymous jury. It was in one of the motions. They were like, due to his social network on social media, no, we're going to make it partial. So they're going to be anonymous and they will be sequestered during trial. Partially. Now, Miss Esquire, partially sequestered and anonymous, what exactly does that mean? Because people are confused about that too.
Yeah, so partially sequestered means that the jury is prohibited from viewing and participating in certain types of materials.
Mm,
Probably they could not look at certain websites, probably couldn't watch certain television
right.
programs,
Newspaper articles. Right.
newspaper articles, radio, which makes sense because they don't want them hearing things about the trial while they're sitting for the trial.
Right.
So that's the partially sequestered part. Now the anonymous part means that the public cannot know who the jurors are.
Okay.
That is because of the crazy internet people.
Mommy, do you know what they did while the trial was going on?
What did they do?
Two of the bloggers, one was at court, one was doing a live. The blogger that was on court called into the live and said, yo, they got all these jurors. They're coming in now. There's a black guy, a white guy, a tall lady, a fat lady, a skinny this, black hair, this and that, Chinese. Yup. Girl, you know what I did? I recorded that shit and sent it straight to Miss Getty's while she was in court. And she actually said, I'm at trial right now, but send this to my assistant and we will get right to it.
Yeah, that is just so out of line. Nobody went as far as to make this trial, make the jury anonymous Why would you think it's appropriate to physically describe them? Then anyone can just hang out by the courthouse, wait for people who match that physical description.
Right. Right. And then after that, the prosecutors took action and told the bailiffs who these bloggers were, the names of them, because I gave the names. And I told them their channels and all of that. And I told them, explained to them what was going on in the video. And I sent them the video. So they actually saw the proof that I had. And they banned them from the trial. So they removed them from the trial and told them they couldn't come back.
Good. That's all that happened to them, because I'm gonna tell you and sometimes people get so lucky because a different prosecutor could have asked for discipline. A different prosecutor could have said, Your Honor, they are challenging this entire trial. My jurors feel unsafe and I want this person punished. That person could have went to jail.
Right. Right. They could have went to jail. And then the other one, she's a pendeja because she's sitting on there and she's going, oh, okay, and ooh, ha, hoo. And the chat, and her chat was saying, no, stop it, bleep her, cut the live, trim it. What is she doing? No, why is she letting you know? Shut up, shut up. Yo, what's the funniest shit? The things they do for R. Kelly is scary.
Very scary. And I don't know how that would help R. Kelly.
Right. None of that shit was helping R. Kelly. None of it. None of the stuff they do out here, Miss Esquire, helps R. Kelly. Nothing. Nothing. It's making his matters worse. But they don't see that. They don't get it. And it's a damn shame, because for people who say they love R. Kelly, I'm confused. That ain't love. If that's love, I don't want it. I don't want it. I don't want it. So, Miss Esquire, we've been on for 2 hours. I'm not going to hold you any longer, my love. Please, everyone, if you get a chance, please do me a favor. Show your girl some love. Cash App her, $ Felicia P, and it's capital P, lowercase HYLICIA, and then a capital P at the end. Please support my girl. Our woman came here for us, okay? She took a day off, a night off, shall I say, for a few hours to hang out with Diva and OCOV. So please, let's show her some love, okay? Thank you so much, guys. I appreciate your love and support always. Y'all already know. Miss Esquire, do you have any last opinion about what maybe you think might go on next?
So I think that they will continue to battle it out on paper, which is just a slang way of saying via motions.
Right.
And R. Kelly's attorneys are going to exhaust all avenues. Again, because that is their job. And in criminal cases, when your client is found guilty, if you don't exhaust every avenue, then the client can come after you for malpractice. This is their life at stake, right? So they are going to exhaust every avenue. Do not be fooled into thinking that because they file a motion, they think they can win.
Right.
Probably not, right?
Right.
But they're filing the motion to avoid losing their license. It's really that simple.
Right.
Sometimes attorneys do things to cover all of their bases. Right. It does not mean that they really think that that motion will be successful. So do I think that we will see this conviction overturned in any way? I don't think that's likely. But we're definitely going to see motion after motion after motion come out because his attorneys have to do their job.
Right. Regardless of how we feel, his attorneys have to do their job. And the crazy stuff, Miss Esquire, is that whenever something goes wrong with the case, his supporters are quick to attack the attorneys like crazy. They attack them. They follow their Twitter, their Instagram, whatever it is, write them letters, attack them. Attack them.
That's interesting. That's interesting. Well, I want to say thank you to Diva for being y'all. Diva is so amazing.
I love you.
I've said this before, but I don't care. I'm going to say it again. Not only is she an amazing host and has this awesome platform with you, you all here on YouTube, but she's a wonderful person. She does a lot for her family. She does a lot for everyone. She did this Christmas giveaway and, sent me this beautiful jewelry. And so whenever I can, and I know she,
mommy, next time you put on that jewelry, I want a picture. I want a picture of you in it.
Yes. So I know she knows that I'm super busy, but I always carve out time.
Yes.
And I appreciate her for being so understanding with my crazy schedule, but I try to carve out time whenever I can because I love Diva. I love this channel and I appreciate people who are standing for the victims. That is the biggest thing.
Oh my God, I can't wait for you to meet Larry. Oh my God, I can't wait for you to meet Larry.
I'm excited about that. I think that'll be great.
Larry is awesome. Oh my God, he's gonna throw so many questions at you, girl. You're gonna be like, I really love OCOV. I swear to God, I do.
Yeah,
because you haven't met the whole family yet. You haven't, not yet.
I haven't. But OCOV is it, man. Y'all are a real family. You're riding for the victims, and that's who deserves it. Like the parents, don't like the parents. Like R. Kelly, don't like R. Kelly. Whatever, right? But we can all agree that a 14, 15, 16-year-old doesn't have the requisite life experience or mental capacity to be involved like this with an adult. And they're scarred by it, undoubtedly.
That's right.
So they deserve someone sticking up for them.
That's right. And they will get restitution. Oh my God, I can't wait to go to the sentencing. Oh my God. I can't wait. I want to hear their impact statements so bad. So bad.
Yeah, I may come for that as well. I didn't go to anything else, but that's something that I may actually try to attend as well.
It's June 16, Mama. So if we can, I'll hit you up and let you know where I'm gonna be at, and we can meet downtown.
Yes. We'll see if we can make that happen.
Yeah,
I'm calendar right now,
Mama. That would be awesome. All right, Miss Esquire, I love you. God bless you. Please do not forget. Please drop her link in the chat, guys, if you don't mind. Everyone, please go and subscribe to our lady, Miss Esquire. She does a lot of great content talking about current events with celebrities and their legal woes. And she gives it to you straight, very honest. Y'all already know she is the best legalese lady out there who breaks down the shit so we can understand it, because we over here on a GED level, okay? And we are proud. And I'm going back to school to get my high school diploma. So I'm even prouder, okay? Because I want to be a legalese lady like her. Not a lawyer, but I'll be a paralegal. I'll help with the research. I could do that.
And why not a lawyer? What's the reason that you can't be a lawyer?
Girl, it's just too much headache. Oh, I mean, I don't mind being behind the scenes and doing all the research and stuff like that. I'd rather be behind the scenes because I'm too emotional to be a lawyer.
Well, you can be behind the scenes and be a lawyer. You can be a transactional lawyer. Even in criminal law, you can be a motion attorney. You can be an attorney that just does the writing.
Really?
Yeah. Yes, you can.
I didn't know that.
Attorneys who never see the inside of a courtroom. Mind you, I like courtroom stuff, but many attorneys don't. There are many attorneys who don't like the courtroom and they never see the inside. And when they do have to go to court, they hire someone like me to do it for them.
Oh, shit. Okay.
They don't want to go to court. And I'm totally fine with that. I'm like, oh, you have a trial, you want me to do it? Totally fine. And that's how some attorneys are. There are some attorneys that just don't do litigation at all.
Right. And if you do need a defense attorney, you can reach out to her. She's a defense attorney, right? For criminal?
Who, me?
Yeah. What are you again? What are you doing now?
No, honey. I'm a former prosecutor, but now I practice civil litigation.
Oh, right. She's doing civil now. I'm sorry. Right. You changed to
so
civil.
I have the criminal law background.
My bad. I forgot. Right. That's right. That's what it is.
It's okay.
She does civil with corporate, right? Is that what it is?
Yes. Civil litigation, trademark. right?
Trademarking.
Trademark, business formation, contract disputes, right? And also a special practice that is called brand management, where I assist social media influencers and YouTube platforms in curating their brand.
Right. See?
But I do not practice. My knowledge of criminal law comes from my former life as a prosecutor. That's where I bring that knowledge in. I don't do criminal defense. And it's funny you say that, because there are a couple of things that I don't do. One is criminal defense, and two is family law.
Really?
Yes. And people keep telling me, oh, you could make so much money. And I said to someone the other day, I said, just because I could make money doing something doesn't mean that I should be doing it. And they were like, yeah, hold on to that. Just because I can make money does not mean that I should be doing it. People don't know what criminal defense attorneys. Do you think Bonjean gets any sleep? Do you think
she's up like a freaking owl, this lady.
These criminal defense attorneys don't get any sleep. They have stomach ulcers. Same thing with family law attorneys. No sleep, stomach ulcers, stressed out, losing their hair. Listen, I'm on this earth to see at least 100 years on this earth. And there's no money that's worth me lowering my life expectancy. The next thing is a lot of the female criminal defense attorneys, female family law attorneys, they don't even have a family themselves. They don't have time. Right? That's another thing.
Interesting.
I don't want to be that person whose life is all contained in the one box of me being an attorney. I fully intend on being mommy and wife and all these other things.
Right. You do have other goals and aspirations, right?
Exactly. So just because I could make money doing it doesn't mean that I should be doing it.
I get that shit. You know, it's just like some people out here on YouTube. I agree with that same statement for the people on YouTube.
Listen, don't even get me started on the people do whatever. And that's another thing. I'm glad you brought up YouTube before I get off here.
Yes, ma'am.
So many people do any and everything they need to do on YouTube to be popular.
Right.
Any and everything. They talk about anything that's popular.
Right.
They do any prank, any video, I saw someone the other day talking about a medical procedure, a very, very personal medical procedure that they had. Now, is it their right to talk about it? Sure. But why would you want to talk about that online?
Oh my God. That's funny you say that, Miss Esquire.
Yeah.
We seen some dude who actually showed his stages of after he got a circumcision as an adult.
Oh my gosh.
Girl, we saw his wee-wee and his cut, and he kept showing us how he went through different stages and changing his gauze. And
wow.
Like, I'm like, do people really want to see this for real? You should have seen the views on the shit.
I don't know who would want to see it, but listen, people have no boundaries. We don't believe in privacy anymore. We don't have any boundaries. People post anything that will make them popular. And so here's the last bit. I'm really going to go now because I'm about to fall asleep. But
yes.
Someone mentioned my channel the other day, and they said, you know, you should have so much more subscribers, and you should have so much more views. And you know, how do you feel about this or feel about that?
Right.
The amount of subscribers I have on my channel and the views that I get on my videos say nothing about my worth.
Right.
I get my self-worth from YouTube. So I don't need to come on here and show my butt crack and be toxic K and be. There are some attorneys on here, they are ashamed to the bar. And
oh my God, I've seen some of them, girl.
Those are the attorneys that are viral. But guess what the funniest thing is about those attorneys? They don't have a real practice.
Right.
And people don't know that. Of course, you're going to come on here and show your whole butt crap for YouTube personality and YouTube fame because you need YouTube money because you're not a real attorney.
And you're not producing real content.
There you go. So for me, listen, I'm here in this space. I'm going to teach. If 2 people watch it, I'm glad to have those 2 people.
That's right.
But my validation and my income doesn't come from YouTube. And that means I'm not a slave to YouTube and popularity.
Hallelujah. I feel the same way, sister. I'm not a goddamn slave. This is not my life. Yes, it is a part-time gig, and that's what it is, a part-time gig.
Yep.
This is not my life. This is not my job. My job is my family. That's my
Exactly.
job. That's my
Exactly.
job.
And don't let anyone tell you that it is not a profession that is worthy of praise.
Thank you, Mama. A lot of people don't acknowledge that, and you're absolutely right.
That is a shame. That is a shame. It's a profession just like any other.
Hmm.
You should be just as honored and valued for raising your children and being a wife as I am for being an attorney.
That's right. That's right. Amen. So, guys, make sure you guys don't forget, do me that favor, please. Hit that like button if you are not subscribed to my channel. Please make sure you hit that subscription and hit the notification bell on the side. All right. If you're not part of my members only club, it's $1.99. It's not very expensive. It's cheap, y'all. Okay. And you can come in and I do exclusives and private screenings and things of that nature. And if you have any comments below, please leave your comments in the comment section of the video. Thank you. And Diva and Miss Esquire are out. Peace.